Messages from the House.
From the House of Representatives, March 26, 2021, message number 296, referencing Senate File 13. Mr. President, Senate File 13 passed on third reading in an amended form by the votes indicated. Ayes 52, noes 8. The House respectfully asks the Senate to concur. Signed, Wendy Harding, House Chief Clerk. Message number 299, March 26, 2021. Mr. President, the following bills failed to pass the House third reading by the votes indicated. Senate File number 30, Pandemic Response Review Task Force, ayes 25, noes 35. Signed, Wendy Harding, House Chief Clerk. March 26, 2021. Mr. President, the following bills passed the House on third reading by the votes indicated. Message number 297, Senate File number 21, Judicial Review of Agency Actions, ayes 60. Message number 298, Senate File number 23, Public Meetings, Executive Sessions for Security Plans, ayes 59, noes 1. Message number 300, Senate File number 35, State Budget Department, ayes 35, noes 25. Signed, Wendy Harding, House Chief Clerk. March 26, 2021. Mr. President, the House failed to concur on Senate amendments to the following bills. Message number 307, ayes 13, noes 47 on House Bill number 73, Birth Certificates, Gestational Agreements. Message number 305, House Bill number 7, Air Ambulance Membership Organizations Regulations, ayes 3, noes 57. Message number 301, House Bill number 49, Agency Fee Revisions, ayes 4, noes 56. Message number 309, House failed to concur on House Bill number 121, State-Funded Capital Construction, ayes 14, noes 46. Signed, Wendy Harding, House Chief Clerk. March 26, 2021, Mr. President, the House did concur on Senate amendments to the following bills. House Bill number 304, or message number 304, correction, on House Bill number 91, removable of unenforceable property covenants, ayes 60. Message number 303, House Bill number 57, advance enrollment, ayes 60. Message number 302, House Bill number 54, Wyoming Meatpacking Initiative, ayes 53, noes 7. Message number 306, House Bill number 58, State Parks Account Expenditure Authority, ayes 39, noes 21. Signed, Wendy Harding, House Chief Clerk.
Reports from standing committees.
March 26, 2021. Mr. President, Committee number 1, Judiciary, to whom is referred House Bill 41 engrossed, Interstate Crowdfunding Exemption Amendments, respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, Chairman. Message March 26, 2021, Mr. President, to Committee number 1, Judiciary, to whom is referred House Bill 43, Digital Assets Amendments, respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, Chairman. March 25, 2021, Mr. President, Committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred House Bill 229 engrossed, Livestock Identification Choice Act. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Boner, Bouchard, French, Cost, and Wasserberger. Senator Boner, Chairman.
Signing of enrolled acts. We're at that order of business, signing of enrolled acts. House Enrolled Act 19.
House Enrolled Act number 19 being original House Bill 4, an act relating to the Mental Health Professions Practice Act.
About to sign House Enrolled Act 19, same being original House Bill 4. So signed. House Enrolled Act 20. Reader?
House Enrolled Act number 20, being original House Bill number 20, an act relating to motor vehicles.
I'm about to sign House Enrolled Act 20, being original House Bill 20. So signed. House Enrolled Act 21.
House Enrolled Act number 21, being original House Bill number 29, an act relating to indigent person burial expenses.
I'm about to sign House Enrolled Act 21, being original House Bill 29. So signed. House Enrolled Act 21.
House Enrolled Act number 22, being
Excuse me,
original
House Enrolled
Bill-
Act 22. Go ahead.
House Enrolled Act number 22, being original House Bill 33, an act relating to crimes and offenses.
I'm about to sign House Enrolled Act 22, being original House Bill 33. I've so signed. House Enrolled Act 23.
House Enrolled Act number 23, being original House Bill number 46, an act relating to crimes and offenses.
I'm about to sign House Enrolled Act 23, being original House Bill 46. I've so signed. House Enrolled Act 24.
House Enrolled Act number 24, being original House Bill 69, an act relating to banking and commerce.
I'm about to sign House Enrolled Act 24, being original House Bill 69. So signed. House Enrolled Act 25.
House Enrolled Act number 25, being original House Bill 86, an act relating to motor vehicles.
I'm about to sign House Enrolled Act 25, being original House Bill 86. I've so signed. House Enrolled Act 26.
House Enrolled Act number 26, being original House Bill 87, an act relating to the Provider Recruitment Grant Program.
I'm about to sign House Enrolled Act 26, being original House Bill 87. I have so signed. House Enrolled Act 27.
House Enrolled Act number 27, being original House Bill number 111, an act relating to healthcare.
I'm about to sign House Enrolled Act 27, being original House Bill 111. I have so signed. House Enrolled Act 28.
House Enrolled Act number 28, being original House Bill 118, an act relating to marketing homemade foods.
I'm about to sign House Enrolled Act 28, being original House Bill 118. I have so signed. House Enrolled Act 29.
House Enrolled Act number 29, being original House Bill number 120, an act relating to the Hathaway Scholarship Program.
I'm about to sign House Enrolled Act 29, being original House Bill 120. That concludes our enrolled acts. Okay, we'll move on to consideration bills on general file. Before I do that, I'll just take a moment for privilege right here. If I could have the mayor of Thane, Mayor Simpson, stand up in the back galley there and say hello to the Senate. Mayor of Thane, Wyoming, right there, folks. Mayor, thanks for visiting the Capitol today. Appreciate having you over here. All right, let's return to Mr. Majority Floor Leader.
Waiting for you.
Mr. Majority Floor Leader, we're at that order of business, consideration of bills on general file.
Mr. President, I move the Senate resolve itself into committee of the whole.
For the motion, all those in favor say aye. Those opposed, nay. Senator Cooper, with only one no vote, you return to the chair.
Committee of the whole, please come to order. The next bill for our consideration is House Bill 115. Reading clerk, would you read the bill, please?
House Bill 115, big or trophy game animal minimum hunting age, sponsored by Representative Paxton. An act relating to game and fish was referred to committee number 6, which returned a committee recommendation that it do pass. Ayes Senators Guru, Landon, Salazar, and Schuler. Excuse Senator Ellis. Senator Schuler, acting chairman.
Having read the bill, what is your pleasure? Senator Schuler.
Thank you, Mr. Chairman. I would move that when the committee of the whole rises to report, it do so with the recommendation that House Bill 115 do pass. And with that, I call on, I'm not sure if it's Hicks or Driscoll, must be, I'm not sure which one is going to carry the bill. Is it you, Senator Hicks? If not, I can do it. Looks like they're busy. Okay, I guess it'll be me. Okay, this is a really simple bill. I've said that before. Okay. Anyway, this is so simple. On page 1, if you'll take a look down on line 11, this is really the meat of the bill. And we're just asking that the minimum age to take a big or trophy game animal is 12 years of age. That's in statute already, except, this is the new language, that any person may take a big or trophy game animal at age 11 years of age if the person will attain 12 years of age by the end of that calendar year. And again, there was some discussion about making sure that they had permission from their parents or grandparents, whoever was going to be taken, and that they have to be accompanied by someone over the age of majority who possesses and can exhibit a certificate of competency and safety. And that's pretty much it. Also, the person that's with them has to have had a big game hunting license within the last 5 years. If they are a parent or guardian, and if they're someone accompanying them that is not their parent or guardian, then the hunter has to have in his possession a permission slip signed by his parent or guardian allowing him to hunt. So it's a really simple bill. I think it's a good bill. I think we had a lot of testimony about, there was a testimony from a grandmother who talked about the fact that she was out hunting and wanted to take both of her grandsons. One son was a little bit older. The other grandson was 11, was going to be 12, like within just a short time, and wasn't going to be able to go hunt, even though she felt like he was physically, mentally, and socially ready to hunt. So I think this is a good bill, and I stand for questions.
Sounds like you're ready for the question. All those in favor of Senator Schuler's motion that when the committee of the whole rise to report and do so with a favorable recommendation of House Bill 115, please say aye. Aye. Those opposed? Okay, House Bill 115 has passed the committee of the whole. The next bill for your consideration is House Bill 144.
House Bill 144, Electric Vehicle Fee Update, sponsored by Representative Brown, an act relating to multi-purpose vehicles, was referred to committee number 8, which returned to committee recommendation that it do pass. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Pappas, acting chairman.
You've heard the reading of the bill. What is your pleasure, Senator Landon?
And I'm looking out across the room to Senator Nethercott for an explanation of the bill. Thank you.
Thank you, Mr. Chairman. This good little House bill, what it does is it corrects an oversight from the bill that was passed last year requiring a fee for electric vehicles. What inadvertently happened, I think in the legislation previously, was that it subsumed into it motorcycles and ATVs and other electric type vehicles, which is not the intent. The bill is really intended to, and the fee is intended to focus on cars and trucks that are electric. And so what the bill does is it exempts out those recreational vehicles that may have electric components to them, but aren't considered to be an electric vehicle as intended by the bill. So with that, I'd stand for questions.
Mr. Chairman,
Yeah, Senator Case.
I'm not seeing the penalties in this bill. I wonder where they would be. Is there a felony?
In a response. Oh, there's Senator Hicks.
Mr. Chairman, this is a revenue decreasing bill, and I was wondering if it was re-referred to the Revenue Committee.
Questions called for the bill. All those in favor of Senator Landon's motion that when the committee of the whole rise to report to do so with a favorable recommendation on House Bill 144, please say aye. Those opposed?
No.
House Bill 144 has passed the committee of the whole. The next bill for your consideration is House Bill 193.
House Bill 193 engrossed County Attorney's Representation of Special Districts, sponsored by Representative Kriegel, an act relating to county officers, was referred to committee number 1, which returned to committee recommendation that it do pass. Ayes, Senators Cooper, French, and Cost. No, Senators Kolb and Nethercott. Senator Nethercott, chairman.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the do pass recommendation of House Bill 193. And to explain this good little bill, I'll call on Senator Cooper.
Senator Cooper.
Thank you, Mr. Chairman. In the words of my good committee chair, this is a really simple bill, which should just scare the heck out of all of you. So I bring before you today House Bill 193 and ask for your favorable consideration. Essentially, it allows our 23 county attorneys to represent any special district located wholly within their county. I'm bringing this bill to solve a problem in several counties around the state. For years, these county attorneys have represented a few of the special districts, such as the cemetery district or Whedon Pest or something of the nature in their counties. Might be a solid waste district, quite a few other things. Sometime this past winter, one of the state's county's attorneys requested an opinion from the chief attorney of the state regarding this matter and was instructed by said attorney that there is not statutory authority for a county attorney to represent any special district. As a result, this bill is brought so that these county attorneys may continue to represent some special districts in their counties. This bill will allow each county attorney to continue to do as it deems appropriate. It only has to represent who he chooses to represent. The language in this statute is very permissive intentionally. It does not mandate anything. In small counties, and there are several of them, it will mean thousands of dollars in taxpayer savings for these districts. And I will reiterate that this bill does not require any county attorney to change its current operations. Rather, it gives those who want to the authority to do so. Now, I'm going to walk you through this bill real quick. On page 1, it creates section 16-12-203, where it states that special districts may request legal assistance from the county attorney. On page 2 in 18-3-02, it sets forth that the county attorney's duties. It creates subsections D that states the county attorney may represent a special district. Also on the engrossed version, which we're working from, there was an amendment, second reading amendment. That amendment pertains to the language on page 2, lines 2 through 7 and lines 15 and 16, and essentially requires that the applicable county commissioners approve the representation. This amendment gives the commissioners who pay for the county attorneys, pays their salaries, some kind of say in the matter. It also helps address any conflicts of interest ahead of time that may be come from the representation of a special district by the county attorney. Finally, the effective date is July 1st. Thank you. Gladly stand for questions.
Senator Coe.
Thank you, Mr. Chairman. Just a few questions. So I guess I'd like to get an explanation on why all the county attorneys in the state of Wyoming, less one, wasn't in support of this. But more importantly, I can talk about my past life as a county commissioner. This came up many, many, many times. Conflict between the Board of County Commissioners and other taxing districts, in this case, a scenario that involved having both parties having other representation. You know, county had the county attorneys and the other districts had their attorneys representing them in that case. There's constantly conflicts with this in one place or another in a county. I think the larger your county, the more you probably run into this. Conversely, the smaller the county, the less you run into this. But it is definitely controversial. I think you have a situation here where you got a county that has 12 mills of tax revenue. And then you have, say, an improvement district of some sorts, we'll just say 3 mills. Well, they have their own revenue source. I think in the world of what I know of attorneys and representation, this mix doesn't work. I mean, you're commingling funds from one entity, the other entity supporting that entity. The entity should stand on its own feet for representation. I think whether I understand there's a convenience factor here, but there's a lot more controversy than convenience. And I wondered how the answer to the question is just why are all the county attorneys against this? Thank you, Mr. Chairman.
Mr. Perkins, Senator Perkins.
Thank you, Mr. Chairman. I don't know why the county attorney's against it, but I have a pretty good idea. And I think it comes back, it's very important to understand about attorneys and representation. Just because the law says you can, as an attorney, it doesn't mean that you can. And that's because attorneys have believe it or not, there's the rules of professional conduct for attorneys, and they're very strict about conflicts. And in fact, if you violate conflicts, that's how you get disbarred and suspended very, very quickly. And you don't get to be an attorney anymore. Now, for some of you, that might be a good idea, and this may be an attorney reduction bill. But in reality, I think what happens, and this is the problem, is when you at some point you can have represented somebody, and then several years later you may represent somebody else against somebody you represented a few years ago, and that's not necessarily a problem if if the issues are discrete, and if when you were representing the first party, you didn't learn anything that gives your new client an advantage because you were representing somebody else before. And that's the crux of this, is that I'm a county attorney. I'm representing the county. The county commissioner says, oh, we don't think it'll be a problem. Go out and look at this board and go out and help them. So they go out and give an opinion. Guess what? The opinion says it's illegal, and maybe they've been doing something illegally or unlawfully for quite some time. Now, what do? The attorney has to go back, and the attorney can't do, the attorney's completely conflict out. So then what has to happen? Now the county is going to have to hire an independent attorney, and the board's probably going to have to hire an independent attorney. And now you're paying two attorneys. So maybe this is really a full employment attorney bill. I don't know. But I think that's the effect. And it just, as you represent people and they tell you things and you learn things that are covered under the attorney-client privilege, once you've learned those things, you absolutely cannot use them to that party's disadvantage later on. And this is exactly where you put these county attorneys. They learn anything that they didn't know, and it's a big problem. It's a big problem for all, not just the county attorney or his staff or her staff, but for the boards, and they'll all end up hiring new attorneys. And it will not turn out well. Thank you, Mr. Chairman.
Senator Nethercott.
Thank you, Mr. Chairman. No voting committee. What the good chairman of appropriations explained is certainly true, and interesting to note that throughout the years, certain AG opinions have been obtained on the issue, identifying those same concerns and the prohibition thereof. And so I think the effort is out of the need of some of these smaller communities to try to somehow overcome that through state statute or some other way. And I just don't think that it's possible. And this is probably, I mean, I recognize the practical need, but it just doesn't work in reality. And there's a reason why the County Attorneys Association is against it, and why it's been prohibited and frowned upon by our senior attorney, and legitimate concerns associated with the concept.
Senator Hicks.
Mr. Chairman, a question for legal counsel on this, getting back to the description from the chairman of Appropriations Committee. How does it work in a situation where you have special districts, that those boards are appointed by the county commissioners? Under those scenarios, does the county attorney then still have original jurisdiction to represent those versus other special districts that are not appointed by the county commissioners? Just curious on that aspect.
Mr. Chairman.
Senator Nethercott.
Thank you, Mr. Chairman. Great question from the Senator from Bags. There is, I think, an appropriate distinction that lawyers and counties need to make on the ground concerning the differences between those commissioner-appointed boards and those that are not commissioner-appointed boards. And whether or not a conflict exists is a question. Certainly in this county, there was a commissioner-appointed board where a conflict did exist, and that commissioner-appointed board ended up suing the commissioners. So there is the possibility for inherent conflict, but I think that on the ground, that conflict doesn't necessarily exist. And there are ways to navigate that pursuant to the rules of professional conduct and other ways for a commissioner-appointed board, which certainly is a safer route than a completely separate special district like a weed and pest district, which is an elected board with its own separate operating budget and those separate pieces. So there's still a gray area, but less concerning than a completely separate special district.
Senator Cooper.
Thank you, Mr. Chairman. There's some really good questions here. In regards to, this seems to be kind of a north against the south thing here. It's on the south wall. In regards to the less than dark-haired gentleman over here, I can't speak to why the county attorneys are against this, but I will say that the county commissioners spoke in favor of it. So within the counties, there is some differences. Some great answers by the chair of the Judiciary Committee. I appreciate her answers. And I will say that in the smaller counties, it looks to me like this bill is doing everything we can do to really encourage and support that critical attorney shortage across Wyoming. We're just trying to limit a few of them. Thank you, ladies and gentlemen.
Are you ready? Question been called. All those in favor of Senator Nethercott's motion that when the committee of the whole rises to report to do so with a favorable recommendation of House Bill 193, say aye. All those opposed say no. Kind of been in doubt. Oh, no. Okay. House Bill 193 has failed Committee of the Whole. Oh, that's right. I'm sorry. We have to do a standing for that. All those who voted yay, please stand. I'm down. I stand up too. All those who voted no, please stand. What'd you say? I didn't hear. Okay. Pursuant to the rule, you may be seated. First of all, pursuant to the rule, we need to do a roll call vote.
House Bill number 193, roll call. Anderson? No. Baldwin? No. Beitman? No. Boner? Excused? Excused? Senator Boner?
Excuse.
Bouchard? No. Case?
Excuse.
Cooper? Aye. Driscoll? No. Ellis? No. French? No. Furphy? No. Guru? No. Hicks? No. Hutchings? No. James? No. Kinsky?
Excuse.
Excused. Cole? No. Cost?
No.
No. Landon? No. McEwen? No. Nethercott? No. Pappas? No. Perkins? No. Rothfuss? No. Salazar? No. Schuler? No. Scott? Aye. Steinmetz? No. Wasserberger excused. President Dockstader? No. Closing vote. Closing. Vote closed. House Bill 193, 2 aye, 24 no, 4 excused.
House Bill 193, having failed to roll call vote pursuant to Senate File 6-SA is deemed indefinitely postponed. The next bill for your consideration is House Bill 102. Clerk, read the bill, please.
House Bill 102 engrossed, Wyoming Preference Act of 1971 amendments sponsored by Representative Barlow. An act relating to the Wyoming Preference Act of 1971 was referred to committee number 9, which returned to committee recommendation that it be pass amended. Ayes Senators Anderson, Beitman, Cooper, and Rothfuss. Excused Senator Wasserberger. Senator Anderson, Chairman.
Having heard the reading of the bill, what is your pleasure, Senator Anderson?
Mr. Chairman, I move that when the committee of the whole rises to report it, do so with the recommendation that House Bill 102 do pass. And I'm not sure who was going to take that on the floor. Look everywhere. I don't see any volunteers. Who's on it? Driscoll? Is Driscoll on it? He must be the one going to explain it.
Senator Driscoll.
All right. Where are we?
We'll vote yes, of course. Looks like we've got a standing committee amendment. We have it read in.
House Bill 102, Standing Committee Amendment Number 1 to engrossed copy, page 2, line 7, after.
I move standing committee amendment number 1 to House Bill 102. Folks, this, I'll work it into the bill. It adds days and otherwise authorized Department of Workforce Service rules and proof of residency, and we'll get into that as we go through the bill. Folks, this bill is actually a pretty important bill as far as it goes. We've got a, now I got to pull it back out. So as you go into this bill, it goes back to our Labor Preference Acts and what is a Wyoming resident, and it has to do with resident laborers. And so when we get into highway crews and different areas of Wyoming law, we've got statutes on the book that give preferences to Wyoming people. And what we've had is we've got a loophole in the law, the way it works. We've had people that have got out of prison, as an example, and this is one of the ones that talked to us. Someone that's been residing in Rollins for 6 or 8 years, and they get out and they can't be called a Wyoming resident. And with the other end of them. So what this does, we go back into the act and we're defining a Wyoming laborer. And what it says in the past, you had to be here for a year. It says you have to be in the state for at least 90 days preceding your application for employment. And then we go on to proof of residency in the state of Wyoming should be established through any of the following documents. And this is probably a little stricter in our voter ID. Got to have a current Wyoming driver's license identification card issued under Title 31, the Wyoming statutes. Copy of the applicant's official educational records from Wyoming school or military. Form DD 214 indicates Wyoming's applicant's domicile and home of record at the time of the application. Which once again, they've had troubles with kids that have graduated here. Proof of residency statement on form provided by the Department of Workforce Service has been completed, signed, sworn. D, lab applicant is a minor dependent. Proof of residency may be satisfied through documentary evidence. Minors, dependents, parent, or legal guardians provide subparagraphs A through C. Go on down, Romanet E, any other documentary evidence authorized by rule of Department of Workforce Services. Small v, public entity means that they define it through statutes. And the rest of it's kind of clean up until we get down. I don't have page numbers. So we get down to the employers. They've submit written notice, need for laborers. Notice may include the person's need for laborers on multiple public work. The person is responsible during the 9-month period. Notice should notify the need for laborers consists of an emergency that endangers health, welfare, or safety of the public is determined by the public entity associated with the public work. Person's need for labor substantially changes during the period. Person may amend the written notice. Then Romanet II, we drop down. This is page 5. Thank you. State Workforce Center certifies that persons, and we amend in there, or the emergency exists that endangers health, welfare, same wording that goes through that, goes back to the 9-month period language, except as provided in this subparagraph. State Workforce Center shall respond to a person's request for certification or certification amendment within 10 days. Written notice is received. State Workforce Center to respond to a person's emergency request for certification as soon as practicable, but not to exceed 3 days after the date the emergency is received. Go on down. Romanet III, upon hiring, the person should submit to the State Workforce Center the number of non-resident laborers employed by the person pursuant to that certification issued under paragraph II of this subsection. The public work
for what non-resident labor is employed during the period of certification. Number of non-resident laborers employed during the period of certification shall not exceed the number specified in the certification amendment. Goes back down, and then it's just kind of cleanup work at the end of it. Folks, this bill is really important to our folks that do a lot of the safety work on these highways, flaggers, that type of thing. They move them all around the state, and they've got to recertify them every time they go to a different location. This pulls it all together where they can fill out one certification. They might be working down around Torrington one day, and 2 days later, they're in Gillette. Day after that, they're in Cody working for the same firm, and these guys just get mountains of paperwork. This lines it all up. Good bill that simplifies things. That I'd stand for questions.
What about your?
Any discussion on the amendment? Question on the amendment? All those in favor of Senator Driscoll's motion to adopt standing committee number 1? Okay, all those in favor of Senator Driscoll's motion to adopt standing committee amendment number 1 to House Bill 102. Please say aye. Aye. Those opposed? Back to the bill. Discussion on the bill. Senator Kolb.
Thank you, Mr. Chairman. To the bringer of the bill, has anything changed with the requirements for residency? And could he speak to it? Thank you.
Senator Driscoll.
Mr. Chairman, we moved from 1 year to 90 days in this, and it conforms to some other areas. What it really amounts to is these guys that are here for all summer, they end up being residents now are here. This aligns it in. It's a good change, and fits well with the bill. Thank you. Question.
We're ready for the question. All those in favor of Senator Anderson's motion that when the committee of the whole rise to report that it do so with a favorable recommendation of House Bill 102, please say aye. Aye. Those opposed? No. House Bill 102 has passed the committee of the whole. The next bill for your consideration is House Bill 67. Would the reading clerk read the bill, please?
House Bill 67 engrossed geothermal and hydro-related energy review, sponsored by Representative Harshman, an act relating to the administration of government, was referred to committee number 9, which returned to committee recommendation that it do pass. Ayes, Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, chairman. Was re-referred to committee number 2, which returned to committee recommendation that it do pass amended. Ayes, Senators Guru, Hicks, Kinsky, and Steinmetz. Excused, Senator Perkins. Senator Kinsky, acting chairman.
You've heard the reading of the bill. What is your pleasure, Senator Anderson?
Mr. Chairman, I'd like to delay this till Monday. The person that wants to present it is not going to be here until Monday, and he's passionate about presenting it. So I'd like to delay it till Monday. Thank you.
Without objection. House Bill 67 is laid back for Monday. Laid back to general file. Okay. So the next bill for your consideration is House Bill 38. Would the reading clerk read the bill, please?
House Bill 38 engrossed community behavioral health priority population, sponsored by the Labor Committee, an act relating to public health and safety. It was referred to committee number 7, which returned to committee recommendation that it do pass. Ayes, Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, chairman.
You've heard the reading of the bill. What is your pleasure, Senator Driscoll?
Mr. Chairman, I move that the committee of the whole rise to report it, do so with a favorable reading, favorable. recommendation on House Bill 38 for further explanation. I call on Senator Baldwin. You know, oh, who? Schuler. Senator Schuler, I'm sorry, I did it wrong.
Senator Schuler.
Thank you, Mr. Chairman. I wish it was Senator Baldwin because this is a 26-page bill that, yeah, yeah, question. There you go. Yeah, I'm going to try to do the best job I can with it. And, but I hope I have some good backup from the good senator over there, as well as the good tall senator from Bates Creek as well. House Bill 38. This bill is actually a result of some work that the Mental Health and Substance Use Task Force did. They were tasked with deciding what the role of government is to provide mental health and substance use services to our communities. They looked at the services that we now provide, and they looked at what we're paying for these services, and they had to decide, really, are we paying too much or too little? And the most important thing that the task force looked at is what are our priority populations and how do we prioritize services to those populations? So hopefully this bill will answer some of those questions. So if you take a look on page 1, again, it just kind of goes over the questions. It talks about some of the statutes that were amended or revised. And at the very bottom, I could go over what each of those statutes are, but most of them have to do with public health and safety and hospitalization procedures of the mentally ill and what the Department of Health does and so on and so forth. And I do have all those jotted down. I'm happy to give them to you if you'd like. But anyway, page 2, we define mental health centers now as behavioral health centers. And that's, so you'll probably hear that throughout. And that was definitely a definition that we changed. Page 3 talks about the gatekeepers. This is kind of an important part of the bill. These people are the single point of responsibility for these clients that have issues with mental health and substance abuse. They provide guidance on issues of detention and treatment. And the behavioral health centers do not charge a fee for having these services, but they really are important services, having a gatekeeper. County commissioners will give preference to the behavioral centers for service. That's on line 14, I believe. And so basically they will go to these people first and try to get a gatekeeper so that they can have one-on-one with their clients. And I think they've been very successful over the years. Page 4, there's a section there talking about the Department of Health assuming part of the expenses if they do have to contract through a behavioral health center. And I think that's probably pretty much, no, that was line 14. There you go. The department may only assume part of the expenses associated with the gatekeeper if they have to contract through a behavioral center. And the 35-1-613, it talks about community boards. Page 5 begins a discussion of serving these priority populations. The only big change on that page is probably we changed substance abuse to substance use. So you'll see that throughout the bill. And then over on page 6, it continues with more definitions. They define mental illness, they define substance abuse, adults with acute mental illness on the bottom there, behavioral health centers over on page 7. They'll get into adults with severe mental illness. And I think in the middle of page 7, you might want to take a look at that behavioral health centers. I think that's kind of an important definition. They're a nationally accredited organizations that are licensed to conduct business in the state of Wyoming, and they provide a comprehensive range of services for the treatment and management of mental illness and substance abuse disorders for priority populations. Hopefully all of you have some in your county, or maybe you have a couple of them. I think they do some good things. All right, over on page 7. I don't want to miss any pages. Some pages don't have an awful lot of things that are real important. Page 8 gets into general access clients. And so on the bottom of page 8, these are people that don't meet the definitions of a priority population. And we'll talk a little bit more about those later as we go through this. Page 9 gets into, again, more definitions, what the indigent folks are. They don't have private or public insurance that cover their mental illness or substance use treatment. Indigent clients with high needs. They have a mental illness that substantially impairs their ability to function. Non-state level justice involved in the middle of that page. Persons who within the last 6 months have been placed on probation and are subject to intensive supervision programs at the very bottom. People that have maybe been in the previous 6 months have been convicted or pled no contest. and they're ordered to enroll in a intensive outpatient treatment. And then if you take a look at page 10, this defines, this is kind of the important part, I think, of the bill on line 16. This defines the priority populations, and it starts again adding definitions for state level justice involved. I think there's anything else important on that. If you want to take a look on A and B, and I think C is important. Families at high risk are in this group. Adults with acute mental illness, adults with severe mental illness. I'm over on page 11, by the way. 11, indigent clients with high needs, indigent general access clients. And the idea is really what we want to try to do is keep families together, try to keep them stable, keep them living in the community, and not end up with them in our institutions if we can help it. On the middle of page 11, it talks a little bit about the state level justice involved. These are people that within the last 6 months have been released or paroled, but they still require continued treatment for mental illness and substance abuse. If you have questions, feel free to jump in. Page 12, I'll turn around and look. Page 12 gets into the community boards and how counties and cities and school districts can contract with the behavioral centers. These boards provide human services to the county, and there's usually 2 counties. You can have actually 2 counties to have one. There's some places that don't have a community health center or behavioral center now. And so you could actually have 2 counties that could establish one. They can usually offer 1 or more services. So that's pretty much what page 12 does. Page 13 talks a little bit more about the community boards and their powers. It also talks about how the Department of Health won't contract with any of these entities that don't meet compliance with their standards. That's at the bottom of page 13. And then at the bottom of page 14, it establishes the payment policies. It kind of prescribes what the standards for quality of the programs are and what their payment policies are. And then, if I'm going too fast, let me know. Over on page 15, actually in the middle of it, it mentions that if a behavioral center cannot provide sufficient services, the Department of Health can select the most appropriate service. And then we start getting into how we prioritize state funds to these populations. And then we get into the tiers. And obviously at the very bottom of that page, tier 1, these are the highest priority clients, and tier 3 are the lowest. And that's on the bottom of page 15. The idea with the tiers was to try to prioritize our most needy and to try to prevent the recidivism, and maybe have some of these folks that can divert away from our state institutions. So we actually did a couple of different exercises with this task force to try to come up with what those priority populations were, and how to get them in tiers, and how to decide which is the best level of care for them. If you want to go over on page 16, it goes into those tiers, tier 1, tier 2, tier 3. And those are all, these are all ones that the state has the responsibility right now. At the bottom of page 16, it mentions that behavioral health centers can be eligible to receive essential subsidy payments only if they demonstrate a need for operational cost assistance from the Department of Health. And the amount of those shall be based on funding and whether or not the total population of the area that's served by that center, and how many behavioral providers are within a 35-mile radius. And that continues over on page 17. The centers, we did have some questions about general access patients. Can they still be treated? And yes, they can. The centers can still treat those general access patients, as you can see on the bottom of page 17, provided that the service is funded through a combination of sources other than state funding, and as long as the priority populations are not materially diminished. So you can still provide services, but if you got people in those tiers that are ahead of them in the line, they kind of get shoved to the end of the line. On the bottom of page 19, I don't think there's anything on 18 that's of any, we just go ahead and we talk about substance use rather than substance abuse. On page 19, on the bottom there, it does mention that the division will terminate a contract with a behavioral health center if after a hearing, they find that the provider is not using those contract funds for contract purposes. So it does kind of give an out for the division if we have some bad actors. Want to go over to section 20. Let's go to page, let's go to page 21. On section 3 on the bottom of page 21, The Department of Health will consult with the providers and stakeholders to look at the following subjects. They'll get into eligibility requirements for the receipt of state funding with these priority populations. And they'll also come up with some methods for establishing the manner in which these essential subsidy payments will be provided. And they'll start looking into the areas. Is our access adequate where we are with our, not only with our priority populations, but also our general access clients. And then on the bottom of page 22, there's a section on there, talks a little bit about pay for performance that actually rewards providers for administering the case management process and for achieving outcomes that support independence and self-reliance. And those are mentioned on page 23. One of those is hopefully the prevention of a psychiatric hospitalization. That's A. B, prevention of reincarnation, yeah, in an institution. C, competitive employment in an integrated setting. And D, independent housing. And then if you want to go over the next page, it does talk a little bit about the fact that the department will report. It doesn't have to be a detailed report, but they want to have an update to the Joint Labor, Health, and Social Services Interim Committee, and really try to find out whether or not these reforms are doing what they're supposed to be doing, whether or not we're headed in the right path, basically. And so if there's some things that need to change, or funds need to be repurposed, this is what the detailed report will tell us. And then on the very bottom of page 24, then the Department of Health will also, and again, we had a little issue with just the dates, because on the top of page 24, it talks about September 1st, 2021. That first report is not very detailed, as I mentioned before. It's just kind of an update to see where we are. But down at the bottom of page 24, that's where we get a much more detailed report to the interim committee, and to kind of let them know whether or not, what the status is, how things are going, whether we're doing what we need to be doing, whether or not these redesigns and reforms of these state-funded programs are doing what they're supposed to be doing. So it's a pretty good look back, I think, what's working, what's not working, and what we can do that will better serve these populations. The bottom, page 25, Department of Health will promulgate the rules and regulations by July 1st, 2022. And I think that's about it. I'll stand for questions. Somebody's laughing over.
Thank you, Senator Schuler. I think that was pretty self-explanatory. Senator Hutchins.
Thank you, Mr. Chairman. Just two questions. It deals with the substance abuse / use disorder. I'd like to know why that was changed, and can the use disorders be defined? Thank you, Mr. Chairman.
Senator Kolb.
Oh, thank you, Mr. Chairman. To the good senator from the far southwest. Question, what was the input and opinion from, say, the Board of County Commissioners, who is a big component of this cost? What were their opinions? Was that group in favor of these changes? If you could possibly expound on that. Thank you, Mr. Chairman.
Senator Hicks.
Mr. Chairman, I've got a question. First, I'd like to know how many of these behavioral health centers we have in the state of Wyoming. And now we have a prioritized behavioral health centers. And then we have a provision in here, if we go back to where it gets to the gatekeepers. And with regards to the gatekeepers, what I'm trying to figure out here is these behavioral health centers are going to have a monopoly, because the way it's worded now, if you have a county program set up and you have a gatekeeper provision set up in that, unless they are, the way I understand this, unless they're contracted through a behavioral health center, they're not eligible for reimbursement. And so my concern is if we don't have a lot of providers, behavioral health centers scattered all around the state, what you end up is you end up with a monopoly that gets to pick and choose their gatekeepers and may limit the ability in some other areas of the state of Wyoming. Maybe that's an unreal outcome, but I'm just curious how many there has. Why does the gatekeeper provision have to be contracted with the behavioral health center before they can be reimbursed?
Thank you, Mr. Chairman. I'll try to answer them backwards. First of all, I think there's around 30, one of the other senators may know exactly, 30, I want to say 33 of these community health centers or behavioral health centers, but I'm not going to say for sure on that. There still is a place for the private, if you have a private practice, but if you look on page 3, it just says the department in consultation with the Board of Commissioners, they may establish a single point of responsibility, which is the gatekeeper. And the gatekeeper is part of that behavioral health center. But honestly, we actually had I think we had a couple of people that testified and asked, well, if the county boards and the community health centers, if these boards are giving all the work to the gatekeepers and the behavioral health centers, is there a place for us? And yes, there is. There are going to be sometimes a specialty where we have 2 community health centers just in my own community. There may be a specialty there that they can't take care of or they can't deal with. And that's a really good time to try and contract with a private provider that can bring that specialty into play. So even though it does say they will give preference to the behavioral health centers, they're not going to give them, they're not going to get all the work. There's always room for the private providers there. Let's see the second question. There was a number of outreach opportunities for our county commissioners. I think everyone on the task force had reached out to people in their area to talk to them a little bit about the county boards, the county commissioners, to find out what they felt like. I know I did. They were in favor of this. I think they felt the same way, that sometimes when you go to your human services board as a county commissioner, sometimes you feel like you're the last man in and you don't always know what's going on. I hope anyway, that this bill will give some clarity to that and help those county commissioners with understanding that we do have priorities, we do have tiers. We're going to try and take care of these populations first and move on down. I think it will help our behavioral health centers as well to have things prioritized a little bit. And then the last part, I think the last question was why do we change use from abuse to use? And I'm not sure I can remember that conversation, but maybe one of these other senators can. I don't know if it was just taking a negative and turning it into a positive. That would be a guess on my part. So I'm not real sure on that, but maybe one of the other senators here can follow up on that one. Thank you.
Senator Steinmetz, I'm sorry.
Mr. Chairman, I don't have answers. I just have more questions. So on page 14, we start talking about some changing language there, and it says that we're going to establish payment policies for state-funded services provided to the priority populations. And I'm just wondering the stricken language, why we took that out, because we had a uniform schedule of fees for which were set as guidelines, and we were evaluating the client's ability to pay there. And now we're putting in the client's ability to pay and utilize general funds authorized for expenditure as a payment of last resort. So now we're talking about general funds there, which there's really not a fiscal note. So I haven't seen that part of it. And then let's see, we go down. There's a little more down farther in that page. Well, anyway, we can start there, and then I might find that other question I had. Thank you, Mr. Chairman.
Yeah, and Mr. Chairman, because I have a question on the same thing here on page 15, line 14, that my colleague from Goshen County talked about. Why did we call out general funds? Is there some of these programs, my understanding, there may be federal funds available for some of these. And here it specifies general funds. So just a question on that. Is there federal funds available for Title 25 and some of these other programs.
Senator Scott.
And Mr. Chairman, I'm not going to be able to answer all these questions, frankly, because I'm having trouble hearing. The question on the general and federal funds. There used to be a lot of federal funds in this area. I think they have greatly diminished, and we're now primarily talking about general funds and the mental health centers and really your behavioral health centers here. That's just a new name for the community health, community mental health centers. We're primarily talking general funds, particularly for these priority populations. They'll use for the general access population. They will not be able to use in most of them much in the way of our general funds. The whole point of this bill is to be able to, as we cut back and focus in our attention, the point of this bill is to say, look, we really are going to set some priorities here and treat the people who are at real risk of being institutionalized. And that's primarily going to be done with general funds. They'll use their own fundraising, some of their fees and whatnot to deal with the general access population. And that will be a significant change here. So I don't know that that answers the questions. And again, Mr. Chairman, frankly, I was having trouble hearing the questions.
Senator Schuler.
Thank you, Mr. Chairman. Just to kind of piggyback on the good senator there from Natrona County. Yeah, if you look on the bottom of page 14, there was a change made there. And the payment policies, I think, are determined exactly as the good senator mentioned, taking a look at what federal funds are available versus private funds. And also, if you take a look on the top of page 15, they'll take into account on page 15, line 3, 4, and 5, the priority populations, but they'll take a look at their ability to pay, and they'll utilize general funds for expenditures as the payment of last resort. So in other words, if a client does happen to have some private insurance, they'll take that into account. If they have nothing, again, they'll take that into account. But the idea behind this bill is to prioritize populations and prioritize the payments so that we're not just throwing money at everybody that walks in the door. We're trying to prioritize which populations are most in need and taking a look at what services they need, and then also taking a look at what kinds of funding they may have need for or have already. A good share of them may not have any private funds, but some of them may. And so again, that part on page 15, line 5, the payment of last resort will be the state. I hope that clarifies that. Thank you.
Further discussion. Oh, there we go. Mr. Rothfuss.
Thank you, Mr. Chairman. I have a few questions, and there are some things that are a little unclear in concept, and then I think I've got some detailed questions also. But as far as the conceptual questions, the first is one of the things this appears to do is prioritize these community behavioral health facilities and put them as the gatekeeper, preferentially if there's going to be a gatekeeper and if a program is developed by the county commissioners, as I understand it. What I'm not understanding, because this is not something I'm particularly or deeply familiar with, is who is that as opposed to? I mean, a lot of what we're talking about contemplates a fixed pie of resources and a fixed pie of providers that are already out there. If we're shifting to something, we're shifting from something. And I'm failing to understand and just don't know personally, I think, what we're shifting from that's already being used where we're providing a preference, and why is it better now if we were to go with this? And for, again, a fixed pie of resources, if we're shifting resources to these community health providers that are being prioritized from whom are we shifting those resources? I'm assuming someone's suffering, but I don't know who it is. And that's my first question. I'll stop there because it's the finance side. I just want to know how that works.
Senator Scott.
Mr. Chairman, and these shifts were largely made some time ago. We introduced the gatekeeper concept when we were trying to get the Title 25 problems under control. I think at that point we had, yes, I know we had moved over to the Jonah building. So I think about 3 or 4 years ago. We had Title 25 task force, I believe. A senator on our committee from up in the Bighorn Basin was our expert in mental health, and he pushed these gatekeepers as a solution to a number of the problems we were having. In my community, what happened was the de facto gatekeeper was a private organization that was in the business of treating severely mentally ill in-house, and the results of that gatekeeping were, as you might expect, quite expensive to the state. And we shifted, and in that case, to the community mental health center, and reduced the expenses of the state quite a bit. And I think over the state as a whole, these gatekeepers largely came out of the community mental health center, because in many communities, that's where you have the necessary professionals, and they don't necessarily have a personal axe to grind in this thing. So it's an improvement. So this is largely codifying a system that has worked, and the testimony in committee was that this was working quite well, and the provisions here were appropriate. And as far as providers and the local community, in many communities, the problem is not which provider gets it, but who can you find that will do it? We have been short, and who can get paid how, and that's an issue. So it is often the community mental health center, but that has been one of the things we have done that has been successful in trying to get our Title 25 expenses under control. So, Mr. Chairman, I hope that answers the question.
Senator Rosas.
Thank you, Mr. Chairman. And Mr. Chairman, the second question, okay, that kind of gets a little bit at why we're providing that preference. Sounds like we're putting into statute what's in practice right now. Getting though to the financial shift, I didn't get a sense whether there were dollars being shifted towards or away from specific businesses or entities, and if that could be addressed perhaps in the next time, if this changes the flow of who ends up receiving the dollars, where we're biasing it from, one provider or service to another provider or service through statute, I guess is what I'm getting at. Are we picking winners? There's a simple way to ask that question. I'll just sit back down while the tall senator answers.
There may be some of that here, although frankly, I think most of the effect has to do with who can get what funding. A lot of the people here are either indigent because of their mental health or substance abuse problems, or not covered by insurance for that reason. And they tend to gravitate toward the community mental health center, and until they're better funded, the private people are not as enthusiastic about treating them as they might. There is probably some push to use the community mental health centers here, although it's quite clear that they can go to private providers if they can afford it. And I think the push is coming more not from what's in this bill, but from who can pay for what and where they have to go to get the services at all. And the way our system is, in some communities, community mental health center is the only game in town. In others, it's the ones where somebody who has, and these people frequently are made indigent by their disease. So they wind up in the community mental health center. So it's more of a financial push than something this bill is doing. Where there is a push is to try to keep people out of the state hospital unless they are so acutely ill, they need to go there to get their, often it's medications adjusted, or to get on medications at all when it's a first episode of a serious mental illness. And we want to hold that down and use community alternatives as much as possible for obvious reasons. If you can treat somebody closer to home, it's better for them, and it's certainly less expensive for the state. It's not always possible where the illness is severe. You need to go to the state hospital for a while. So, Mr. Chairman, I hope that answers the question.
Senator Rothfuss.
Thank you, Mr. Chairman. And that gets to actually the next line of questions that I had, which relates to the prioritization. And it takes a bit of tracking through to figure out what the tiers do and how the prioritization works. But the idea of using these programs to prevent people from going into the criminal system and therefore saving a substantial amount of money, I guess I'm missing how this accomplishes that. As I understand it, the tier 1 priority population, let's see where that went. The tier 1 priority population gets to folks where state level justice is involved. This is on page 10. Non-state level justice involved, families at high risk, adults with acute mental illness, and adults with severe mental illness. So that's tier 1, and those are the folks that are already, particularly at the top, in the criminal justice system as the highest priority. And then tier 2, even though it's called a full tier, seems to be indigent clients with high needs, which seem to me like the most likely people to next be in the criminal justice system, but we have them at a lower tier. And then the third tier is indigent general access clients. So if money goes away to the point, and it's a prioritized tier system, so if money goes away to the point where we can't really get to the folks below tier 1, it's my understanding that we're basically saying, I'm sorry, indigent, mentally ill folks, we can't serve you. And I guess that scares me a little bit that we're creating this prioritization system that seems to be fueling the future expenses of the criminal system and the correction system. And that would be question. I'll just stop right there. That's a good point to stop. Is what am I missing there on that? Because it seems that this structured tier system that creates everybody that isn't indigent as the high tier and everybody that is indigent and therefore unable to pay as the lower tiers does a lot of the exact opposite of what I would expect we would want to do, Mr. Chairman.
Senator Scott.
Mr. Chairman, what we're trying to do here is to emphasize and put a high priority on the people most likely to wind up being institutionalized on account of their mental illness. And that's why you see the populations in the tier 1. The indigent populations, they're the ones, if they're not indigent, they're more likely to be able to get help privately. So they're prioritized, but below the people who are actively at risk for currently going into the institution. And that's why that's structured the way it is. And remember here, we're dealing primarily with mental illness. That is not something that you can do big preventive problems on. A mental illness is a physical illness of the brain. And the more we understand it, the more it's causing chemical imbalances in the brain. That happens when it happens in nature, very much like a physical disease. It's not something you can prevent. It's something you have to treat when it happens, and it's often first expressed in either adolescents or with young adults. That's just the nature of these diseases. You're talking about in good part schizophrenia, things like that. And they're the ones that are going to need the severe treatment. So they're the ones that need to be prioritized because they'll do better if you can keep them outside the institution, if you can. In a really severe case, you can. But they're the ones we'd like to divert to community treatment and to have community treatment available for them when they come back from the state hospital. So that's what's going on there. And the testimony was with the current funding, they expected to be able to treat all the tier 1, but there may be some problems with tier 2 and 3. And frankly, if you know a way to improve the fortunes of the oil and gas business, to get the administration to stop crusading against more drilling in Wyoming, improve our economy so that we can fund those other ones, more power to you. That's, we're having trouble affording everything we need. That's why we have to set priorities. And the people who really that have been served that will lose out with this is some of what we call the general access population. People that do have, frankly, a debilitating mental illness, and I've known some of these, that in the past have been able to get very good treatment from the community mental health center, and now they're going to be dependent on paying for it themselves or on being able to, community to be able to raise some money for the community mental health center, because we do not have the ability to have in our budget enough funds to treat all these people. That's why we're focusing on these priority populations. That's where the most need is. That's where the most expense for the state is going to be. So that's, you're talking about the key provision of this bill, why it's important. Dealing with the cutbacks we have to make in mental health, you need to set these priorities. It's been an issue for, I can remember Senator Schiffer talking about it way back when. But now the need has become acute with our financial problems. So yes, if you're in the general access population, this priority system is going to hurt you. We don't have the money otherwise. It's a money issue, and how do you deal with it in an intelligent way that gets the people that really are a danger to themselves or to everybody else in the community? How do you get them treated? Make sure they're treated within the money that we do have available.
Senator Rothus.
Thank you, Mr. Chairman. Well, I guess based on that explanation, I do have concerns with the idea that it effectively prioritizes anybody who's mentally ill that can afford to pay as a higher priority that will then have some subsidy from the state is apparently more important than those that are mentally ill that can't afford to pay. Because again, that's effectively how the tier system is structured. Now, the exception, I think the Title 25 at the top, if it's criminal justice involved, seems to at that point probably not be an equity problem because it doesn't specifically talk about their income. But the idea that we would use general funds to treat the mentally ill, but actually have a selection committee effectively as these gatekeepers that say, well, do you have funds? I realize you're mentally ill, but do you have funds to pay for it? Okay, well then you can come use some state funds in the community mental health, and you can go in this door. And if you have severe mental health problems, haven't committed a crime yet, but are indigent and can't afford to pay a portion of it will then go the outdoor. And I don't know, I actually find that really concerning, both from a policy standpoint of, it seems that that's the best vehicle to create new mentally ill criminals at that point, by providing and affording no treatment to those individuals that need it most and can't afford it. It's exactly the opposite of what I think we would want to do if we want to slow the problem. And the other thing that I understood from the discussion is the idea that this is really just being driven by the fact that it sounds like we're planning to cut. We want to prioritize. We are also cutting programs in our correction system that would probably prevent this from happening. We're offloading corrections costs due to program cuts onto traditional public mental health. And then by kicking the indigent population aside, probably just cycling them back through the system. So I guess I'm concerned, and I'd ask, I don't see how this saves money in the long run. It looks like it's a cost driver the way we're structuring it as I see it, and I might be misunderstanding it on that. And Mr. Chairman, I'll just ask, because I see the tall senator wants to jump up and answer. So I have a question, which is the final concern that I see right now is the definitions where we're creating all of these classifications. And I would ask, where are these definitions from? Where did we source the ideas of all of these different categories? Are these distinctive categories within the mental health profession that are data driven, or did we emulate policy from another state, or what's the source of these concepts of the tiers? Thank you, Mr. Chairman.
I'll leave the last question to the people who are on that task force. I do know the definitions are a little different from what some of the professions use. They seem to fit our system pretty well. The question on the indigent, what we're prioritizing here is the people that need the services the most, because they are a danger to themselves or to others, because they have had the misfortune of getting these very serious mental illnesses, which is not something they chose to. It's like having heart disease. It happens to. Matter of fact, heart disease is more preventable than these things. And typically, the people in that boat are not going to have great resources. They're typically young, adolescents just above the adolescent age. Adolescence is when they're minors, the system's a little different. But very young people, because that's when this disease tends to express itself. 18, 19, 20, up to 25 or so, typically. Not always, but typically. And even if the family has resources, these are young people starting out and they tend not to. And it is very important for the safety of society to get those people in treatment. The ones in the tiers 2 and 3 have a risk of getting into this more severe group, but they aren't there yet, so they aren't quite as important to us in terms of public safety and getting people treated as the group in the priority one. So I think that's what's going on here. And again, we can wish we had more resources. We can wish that Washington wasn't attacking our economy, but that's not the truth of the matter. We're short on resources. And this is the sort of thing we have to do in order to manage that successfully.
Senator Burchard.
Thank you, Mr. Chairman. I was on the subcommittee and I was adamantly against what's happening in this bill. When they went to a offline task force, and that came out in some of the testimony where one of the lobbyists had said that they had decided and they had decided this and they had decided that. And my question was, well, and I want to be clear that I wasn't invited to those meetings. And I asked if, Mr. Chairman, if, how many stakeholders were there? And nobody had a record of who they were. So I kind of look at this as an antitrust issue where we have, and I think there's a senator that used the word monopoly. That's what I'm concerned about. I don't think this is ready for prime time. I think we need to back up, and I think we need to start over. I don't think everybody who had had their place at the table on this, and that's really concerning to me with the way the gatekeepers are set up, and there's just certain centers. If you go look at the statutes in this, there's only certain centers that have one single lobbyist that are all connected to it, and that's what's happening here. So on and against.
Senator Schuler.
Thank you, Mr. Chairman. Just to kind of hopefully bring this home, I do believe there was quite a bit of input from a variety of sources. The community health centers, which are now called behavioral centers, have been around a long time, and the gatekeeper concept has been around a long time. It's nothing new. It's just something that I think maybe hasn't been used as much as it should have. I mean, you've got to remember that the county commissioners and these community health boards are ultimately in charge. They're the final straw with what happens with these patients once they've been referred to a behavioral health center. And the gatekeeper is someone that just kind of, I think it's really a solid idea. And the first time I heard it, I didn't really know what they were, what they did. And I went and visited with some folks that have done this before. And it's somebody that really just kind of keeps track of that client throughout the process and make sure that they're getting the kind of care that they need. So a lot of these concepts that are in this bill are not new. And like I said, the behavioral health centers, they serve our communities, I think, in a very positive way. The bottom line, this task force, this subcommittee was created to try to find out if we can do things better, to find out if we're doing what we need to be doing with our folks that have mental health and substance use issues. And in my community, where we have one of the state institutions, I think this focus was really important for me and for our other elected folks in our area, because we have a number of clients who sometimes transition from our state hospital into our community. And like I said, we have 2 community health centers, and I think they've done a stand-up job really to try and treat these folks after they transition into the community. And some of them stay there, some of them don't. But I think really the bottom line, the subcommittee came up with these priorities, and we did it as a group. And honestly, the priorities that we came up with, we pretty much all agreed with. Not everybody, but pretty much everybody did. And the bottom line is we had to start looking at money, because we knew that with all the cuts that we're taking at the state level with our agencies and whatnot, the Department of Health, we knew would be taking some cuts as well. And so this was just kind of a way to get ahead of the game, I guess, and prioritize populations, which I think we need to. I think if you don't have priorities, I don't want to see anybody left out. And I don't think, I would hate to say that there's not something for everybody that's out there, but maybe, there might be some that might be left out. The bottom line is we've got to take care of the most seriously ill. That tier 1, those folks, they can't function in society. They have to be where they are. And we've got to take care of those folks first and foremost. And then hopefully as we go through the tiers and we prioritize and we leave it up to our county commissioners and our community health centers, our community health boards that try to help determine if we're doing the kind of job we need to with our behavioral health centers, then I think we've accomplished what we needed to accomplish. I think this bill is a good step in the right direction. Do I think it's perfect? No. But I think with the potential of cuts in our agencies, and we've seen it already in our budget, we're going to have to prioritize some things. And so with that, I would ask for your favorable consideration of this. Thank you.
Question on the bill. All those in favor of Senator Driscoll's motion that when the committee of the whole rises to report it, that do so with a favorable recommendation for House Bill 38, say aye. Aye. Those opposed? I'm going to have to ask for standing and division on that. All those in favor, please rise. Those opposed? Don't be a yes. Senate File 38 has passed the committee of the whole. By a count of 14 to 12. Mr. Rothfuss,
Thank you. I believe it's House Bill 38 and
House Bill 38. Did I
Thank
say Senate File? I
yes, you
apologize.
did. No worries. Thanks.
House Bill 38 has passed the committee of the whole. Let's see here.
Mr. Chairman, move the committee whole rise and report.
You've heard the motion. All those in favor say aye.
Aye.
Those opposed?
Stay.
Motion carried.
Read the committee of the whole report.
Mr. President, your committee of the whole, having had under considerations bills on general file, begs leave to report as follows. House Bill 19 engrossed, do pass amended. House Bill 10 engrossed, do pass amended. House Bill 198 engrossed, do pass. House Bill 95 engrossed, do pass amended. House Bill 115 do pass. House Bill 144 do pass. House Bill 193 engrossed, failed to pass committee of the whole and was indefinitely postponed. House Bill 102 engrossed, do pass amended. House Bill 67 engrossed, laid back to general file. House Bill 38 engrossed, do pass. Senators Cooper and Ross, Chairman.
Senator Cooper.
Mr. President, I move the adoption of the committee of the whole report.
You heard the motion. All those in favor say aye. Aye. Those opposed, nay. Mr. Majority Floor Leader, good job, Senator Cooper. Senator Driscoll, Majority Floor Leader.
Mr. President, I would like to refer House Bill 127, Public Health Amendments, from Committee 7 Corporations to Committee 2 Appropriations.
Absent objection, 127 referred to Committee 2 Appropriations.
Mr. President,
Mr. Floor Leader.
I would ask for House Bill 219, Investment Funds Committee membership, be referred to Committee 2 Appropriations from Committee 7, or Committee 2 Appropriations from Committee 7 Corporations.
What? You didn't tell me
You say that, Mr. Floor Leader. Let me make sure I got which committee you referred that. So one more time.
Okay, I would ask to refer House Bill 219 Investment Funds Committee membership from Committee 7 Corporations to Committee 2 Appropriations.
All right, thank you. Absent objection, 219, House Bill 219 referred to Committee 2 Appropriations.
He's gonna object.
Ooh, we might have an objection. Go ahead, Senator, Chairman.
I don't object, I just complain about that. You know, I guess that's the problem, sitting next to majority floor leader, you get dumped on once in a while. No, you know, Mr., may I have to the floor, Mr. President?
Please do.
You know, are the good gentleman, Senator Cooper, had done something they don't see very often. He was president of a committee of the whole, then he stepped down to present his own bill. And then we had the audacity to fail that bill. And then he was made to resume the chair and declare his own bill dead. You would think that the person sitting would at least do that courtesy instead of making him come up and declare his own bill dead. But anyway, it's just an observation, Mr. President.
Senator Cooper, you made history today. All right, Senator Scott.
Mr. President, the custom used to be when your bill failed, you had to get up and make the motion to indefinitely postpone before we made that part of the rules.
Any response, Senator Cooper?
I will comment that I heard something about an open casket earlier. I think that bill arrived here with an open casket, so we just give it our condolences and send it on the road. Thank you very
Going
much.
down the road. Thank you. All right. Mr. Majority Floor Leader, you have some direction for us.
Mike? I don't have the right script. That's all right.
You can kind of wing this one. It's a Friday night.
I think you want to adjourn us.
Mr. President, I've moved the Senate stand adjourned until 10 a.m. Monday, March 29th.
Announcements, please. Senator Scott, then Senator Nethercott.
Mr. President, your committee number 4, education, will meet Monday morning, 8 a.m. down in W10 as per usual. Can try to complete our work on House Bill 173, school finance funding. We took public testimony today. I doubt we'll have time to do any more on Monday, but we may. But we're going to try to complete our work.
Senator Nethercott.
Thank you, Mr. President. Your number 1 committee will meet Monday morning at 8 a.m. to hear the following 2 bills: House Bill 65, political subdivisions deposits, and House Joint Resolution 11, state sovereignty impacted by federal actions.
Thank you. Let's come up to Senator Ellis.
Thank you, Mr. President. Committee number 6, Travel, Recreation, Wildlife, and Cultural Resources will meet next Tuesday, March 30th in Capitol Extension Room E05 and online to discuss interim topics.
Thank you. Staying on the south side of the chamber, Senator Perkins.
Thank you, Mr. President. Committee number 2, Appropriations, will meet on Monday, March 29th at 8 a.m. in room 301 and online to take up the following bills: House Bill 195, Medical Review Panel repeal; House Bill 244, State Investment Administration; House Bill 263, State Coronavirus Recovery Funding; and if time permits, we'll take up House Bill 127. Thank you, Mr. Chairman.
All right. Senator Baldwin.
Thank you, Mr. President. Your committee, Labor and Health, the Perfect 10, will meet Monday morning at 8 a.m. to discuss interim topics with their counterparts from down on the other side of the Capitol.
Very good. Vice President Hicks.
Mr. President, your committee number 12, the ruling committee, will meet in room W2 at 12:30 to take up House Bill 36, Management Council membership, and House Bill 92, the revisers bill.
Thank you. Further announcements. Folks, we're starting to come together, of course, with the joint conference committees. We've got some we'll be assigning Monday morning. We're working out the logistics of location so that people are involved with live stream. So be aware that come together Monday morning. Also, the new composite for the 66th was hung today in the Senate lobby. Please check it out when you leave today with your own photo that's on it. It is on the right side as you exit the double chamber doors. There you go. You've heard the motion. All in favor, say aye. Those opposed, nay. Motion is passed. The Senate stands adjourned until 10 a.m. Monday, March 25th, 29th. Everyone travel safely.